for another Share Custodian video. Among the many valuable services that I provide to viewers of this channel is that I periodically monitor lawsuits involving the AAMC, NBME, NRMP, and other medical governance bodies. Most of that stuff isn't especially interesting or noteworthy, but there is this one case that I've been following for years, and it finally reached a conclusion this summer. And the way it concluded was not at all the way I expected it would. Let me show you something. This is a USMLE score report. It's from a Step 3 test administration that occurred back in 2018, and it was submitted to a state medical board as part of this person's application to receive a full and unrestricted medical license. And according to the words that you very clearly see here, it shows that this examinee passed the test with a 199. There's just one problem with this report. It's fake. In actuality, this person never passed USMLE Step 3. Not then, not ever. So would you be surprised to learn that the person whose name is on this score report is currently a fully licensed physician gainfully practicing medicine in the United States? I thought you might be. So if you're interested in learning how all this came to pass and what lessons there might be in the systems that we use that the rest of us could take from this episode, then sit back, relax, and let me tell you the story of the man who beat the USMLE. The protagonist in our story is someone I'm going to call Dr. B. I guess I should say why I'm going to call him that, because his name is in the public domain. Most of the documents from this case are a matter of public record, so if it's that important to you, you can look him up yourself. But I'm not going to use his name, not because it's a secret, but because the USMLE and the courts and the medical board, they've all fully considered all this, and they all made the decisions that they made. So, in other words, it's a settled issue. I'm telling this story to highlight issues of public concern and draw out some broad and generalizable lessons about our systems and the way they work. So from that standpoint, Dr. B is a very important character in the story, but I don't really want the video to be about him. Anyhow, I'm going to pick up the story in 2018. Up to that point, from what I can tell, Dr. B looked like someone who was winning in medicine and in life. He was an international medical graduate who had beaten the odds not just to land a residency position in the United States, but to match into a highly coveted position at a prestigious institution in the Northeast. And it seemed like it was going well. In 2018, he had first author publications in well-known journals. His headshot on the residency homepage at the time, it looked like it came out of a Polo Ralph Lauren advertisement. He's tan, relaxed, healthy, and above all else, confident, smiling broadly and wearing a navy blazer and a crisp white shirt with a bow tie. But on the basis of the public record, I don't think 2018 was actually a very good year for Dr. B. His passport expired while he was in the United States, and this led to all sorts of bureaucratic headaches, and he had to make multiple trips to the consulate and ultimately back to his home country to get it renewed and keep his visa. And he was having financial problems too. He even got sued by a credit card company for unpaid debts and ended up with a judgment against him for that. And then there was the USMLE. Before he came to residency, Dr. B had passed Step 1 and Step 2 without any issue. But when he took Step 3 in April 2018, he failed. This is his actual score report from that exam administration. He came up just short. He needed a 196 to pass, and he got a 192. So he re-registered to take the test again that summer, but he never ended up taking the test. Eventually, he got a refund. He finally registered and took the Step 3 exam again in December, but this time, he did even worse. He got a 178, which is off the charts low. It's more than a full standard deviation below the passing standard, and this is on an exam that 98% of first-time test takers from U.S. medical schools pass. So in the summer of 2019, he registers to take Step 3 for a third time, but again, he doesn't take it. So he extends his eligibility period, but he still doesn't take it. And finally, on July 31st, the final day of his eligibility period, he sends this email to the FSMB asking them to refund his money. He says that he's been struggling with personal issues that have led to multiple delays, and even sends them some documents from the ECFMG about his visa issues. So the FSMB gives him a partial refund, and that's the last time that anyone at the USMLE would hear from Dr. B until the following spring. As 2019 gave way to 2020, it seemed like life was getting back on track for Dr. B. He was closing in on the last few months of his residency, and he actually had a great job lined up for after graduation. There was just one last little thing he needed to do. He needed to get a state medical license. And so he applied for one, and the board started to review his application. But then, on March 4th, they receive a certified transcript of his USMLE scores. And that transcript shows that he's got 2 Step 3 failures and nothing after that. So, a representative from the medical board reaches out and asks him what's going on. And the following day, Dr. B responds by email. It was all just a mix-up, see? Actually, he passed Step 3 on his first attempt, and he'd been told as much by the NBME themselves. Heck, they'd even refunded him for his second Step 3 attempt when he scored a 178. Actually, I'm going to let him speak for himself because here's exactly what the email said. Hi, Alexandra. Please find attached copies of my Step 3 score report, NBME's explanation, payment transaction report showing the FSBMB refunded me for the second attempt after NBME updated the score of my first attempt. 2 last important points. Please make sure the NBME email copy is kept confidential, as I was required to share this only with my program directors. Also, please let me know if I need to submit another check as my bank cancels checks that are not cashed within a certain period of time. Thanks again for your help. Best, Dr. B. So as you just heard, this email had 3 attachments. One of them was the fake score report that I showed you at the very beginning. The second was a screenshot of his FSMB transaction history, which does show a $775 refund in August of 2019. That was the one that was given in response to Dr. B's email from July 31st, saying that he'd struggled with personal issues that led to delays taking the test. But the third attachment was the real doozy. It was an email that Dr. B said he'd received from the NBME on July 8th, 2019. And although it's somewhat lengthy, I think you need to see and hear the whole thing because the diction, tone, formatting, and minor punctuation errors convey something that isn't captured if I just summarize the thing for you. So here goes. Dear Dr. B, please be advised that our communication, including this email, is as confidential as your NBME examination content. The NBME reserves the right to discontinue examination services to an individual or an institution at any time in order to maintain the security and integrity of NBME's examination programs. However, given the nature and timeline of this issue in your case, it is necessary for you to communicate this information with your program directors. I would recommend that you do not forward this email to your directors and rather relay the message to them in person and advise them to contact NBME with any questions and concerns. Dr. B, I apologize for the delay. I appreciate your patience through this whole process. Thank you for sharing all the delicate information and important documentation that NBME requested. I also appreciate your very detailed email that explained your challenges on your examination day and the negative impact this issue has had on your training. After thoroughly investigating this case and reviewing all the dates of certain reports and of all your requests, it became clearer that the confusion around your USMLE score reports may have potentially stemmed from miscommunication. Your USMLE Step 3 score report was not primarily delayed due to an ECFMG-related matter. The delay was the direct result of the following situation. You were authorized to take this test again, while your first attempt had a score recheck inquiry attached to it. Unfortunately, the score recheck requests take months to be processed when not submitted through FSMB directly. You had initiated this inquiry through NBME. Your updated Step 3 score was available shortly after your second attempt date, reflecting a pass classification. This score report could not be released as you had another active Step 3 application on file. There were multiple failed attempts to contact you by phone in January, February, and March of 2019. Your phone number listed in our system is such and such. Currently, I'm sharing with you your reanalyzed USMLE Step 3 test results of your first attempt, test date April 8, 2018. Once you approve the attached score report, any Step 3 attempts made after the test date on the report will be considered void and removed from NBME's and FSMB's system. You will be refunded for the voided attempt. Please accept my apologies for any gaps in your communication with NBME since the start of this process. It took me a full week of investigation to figure out what has been going on. I can only imagine how stressful this has been for you. I hope this email helped answer all your questions. Given the sensitivity of this issue, we avoid discussing these details with any parties other than yourself. However, if your program directors have any further questions or concerns, please contact NBME to schedule a conference call that you will be required to attend. If we do not hear back from you in the upcoming 48 hours in regards to your approval of the attached USMLE score report, we will consider this score report with a pass classification as your official score report and will route it along with a report of our communications with you to FSMB. Thank you. Yours faithfully, NBME Examinee Support Services. But Dr. B doesn't just send this email to the state board. He also messages the FSMB and NBME and asks them to get this thing straightened out. And as soon as they get their email, the NBME tells Dr. B that they're forwarding it to the USMLE Secretariat, which is their administrative arm tasked with, among other things, leading investigations into irregular behavior, which is the polite term the USMLE uses for cheating and other behaviors that threaten the validity and integrity of the exam and the scores they report. Now, there's a few different logical ways that you could interpret Dr. B's actions. One is that they're the completely expected and rational actions that any honest person would take after they got an email saying that they'd actually passed step 3. I mean, it's frustrating and probably a little embarrassing that they're still out there telling the medical board that you failed, but I mean, it's just a little administrative glitch that surely is going to get worked out quickly, right? But another way to interpret it is that some lies are so big that there's no turning back. Once you've told your story, you got to stick to it. The following day, Dr. B again emails the medical board with the casual self-assurance and grace of someone who's waiting for a silly little clerical error to be straightened out. Hi, Alexandra. This really all comes down to a delay from FCVS, which is the FSMB's Credentials Verification Service, who messed up my score report thing. FSMB submitted a request for USMLE to investigate what went wrong and why FCVS is still reporting failed attempts. FSMB stated this will take some time to clarify and update everything. I'm hoping you won't make me wait for that until I get my license. And again, he attaches a copy of this Step 3 report. At the very same time, the USMLE Secretariat was looking at this score report too, and they quickly determined it was fraudulent. I mean, they could tell that at a glance. Here's the fake score report and Dr. B's real score report side by side. You can see that the word pass and the score are way too large. But the rest of the report actually looks good. If you look carefully at all the other tiny little details, which the NBME did, it looks exactly the way that actual USMLE score reports appeared from the time period from February 2018 to January 2019. The only part that wasn't right was the pass-fail designation and the score, which suggests, of course, that someone created the fake report by photoshopping some text onto an actual USMLE score report. And whose actual score report did the counterfeiter start with? Well, the template turned out to be Dr. B's authentic score report from his April 2018 Step 3 attempt. Like anyone who's taken the USMLE knows, the score report has a second page that shows the examinee's performance by subject area. And Dr. B sent this page to the board too. And out of all 81,372 examinees who took Step 3 during this time period, only one of them had the precise subject area scores that were seen on the fake report, and that was Dr. B. And really, that might have been enough for the USMLE to act on, but the Secretariat wanted to be thorough and do their due diligence, so they investigated the other parts of Dr. B's story. They had their IT folks look at the emails, but they found no evidence that there had ever been an email sent through their servers that corresponded to the one that Dr. B said he received on July 8, 2019. They also pushed him for more details about how it came to pass that this score recheck got initiated in the first place. Because, as regular viewers of this channel know, if you put in a formal request, the USMLE will rescore your exam, but they ain't going to do it for free. These days it costs $80. And yet, as you can see in this sworn affidavit from this NBME official, who I believe is better known for her skills as a psychometrician than her penmanship, they had no record of him ever making a request for a score recheck, and no record of taking any money from him for it. Moreover, as I pointed out when I discussed this in a USMLE mailbag in the past, in all of recorded history, there has never once even been a single person whose USMLE score has changed on the basis of a score recheck. Still, at a certain point, the NBME took it upon themselves to rescore his Step 3 exam just to see if the score changed. It didn't. The man got a 192. Throughout March, there were lots of emails going back and forth between Dr. B and folks at the NBME. Among other things, the NBME pressed Dr. B to send the actual email to them. Initially, he just sent screenshots. When he finally sent the email in native format, after people got to looking at it, they noticed something else that was hard to reconcile. Turned out, the text of the email was slightly different than it was on the original version he'd sent to the state board. As the NBME's attorneys later point out, in other words, at different times, Dr. B distributed different versions of the same single email he claimed to have received from the NBME on July 8, 2019. But Dr. B maintained his absolute innocence. The more questions he got asked, the more insulted and offended he became. Here's one email to the USMLE Secretariat. Hi, Nicole. I would highly appreciate a clarification of what these requests are insinuating, though, because if you would take a minute to actually put yourself in my shoes, you'd realize this whole process should not be acceptable. A trainee who has not done anything wrong should in no way be treated like this when he asks you how come FSMB did not update my score report. Before I move on with this story, I need to remind you about the timeline. All this is happening in March of 2020. You remember what that was like? It was March 13th that President Trump declared a state of emergency and states started to implement shutdowns soon thereafter. What followed was A, an unprecedented period of administrative paralysis and workarounds, and B, an extraordinary wellspring of goodwill toward doctors and healthcare heroes on the front lines. And both of those things are going to be very impactful in the somewhat surprising event that happens next. But first, let me finish setting the stage. The NBME's investigation was thorough, but it wasn't especially fast. I mean, just resolving the details of the FSMB refund, which is the kind of thing you'd think would take about 10 minutes of real work, took a few weeks. And meanwhile, Dr. B is under pressure. He's got an employer who's ready and willing to sponsor a petition for his H-1B visa. But to get that, he needs a full and unrestricted medical license. So he makes a crucial decision, the import of which I'll return to at the end of this video. And he hires an attorney. And he keeps putting pressure on the board to approve his application. Here's another email from Dr. B, and again, I think hearing portions of it verbatim adds some important nuance that a summary doesn't capture. So imagine you're working for the State Medical Board in April 2020, and you get this. Quote, Dear Alexandra, I have not heard back from you re a matter that should have been dealt with urgently, especially with the growing need of physicians in this pandemic. I am shocked to see that my license application is still pending. I gave you the consent to call anyone you want in case you guys do not believe what a physician treating patients in your state up until now is telling you, end quote. Then he plays on how trainees might, potentially, be pulled out of residencies to help care for patients in the ICU and ED, and then he switches to litigious mode, highlighting how he may lose his job and visa, and he concludes by saying, quote, knowing you have all the documents you need, you continue to decline to move forward with my application. I need our lawyer to review this response from you ASAP, end quote. There's a follow-up email where he points out that even the state board wasn't getting quick responses from the NBME, and then he further asserts that he believes he has a legal right to use his, quote, official scores, end quote, by which he means the fraudulent score report that he sent by email. The state board ends up granting Dr. B a medical license. I don't think this would occur in 2024. I mean, regardless of the circumstances, I just don't think you're going to convince any state licensing authority to give you a license on the basis of a PDF of a USMLE score report without the board being able to independently verify it with the testing authority. I mean, getting a medical license is a privilege. It isn't some inalienable human right. You can't rush the board. It's the applicant's burden to demonstrate their fitness for licensure, and the board's got to be satisfied that they're fit, and that's going to take however long it takes. But March and April 2020, that was a different time. This is a huge victory for Dr. B. But Dr. B didn't get very long to celebrate that victory. Within days of the board's decision, he receives a letter from the USMLE Secretariat summarizing their investigation. It's 3 single-spaced pages long, and it highlights the evidence that he engaged in irregular behavior by sending an altered Step 3 score report to the state board. But He gets to have a hearing in August before the USMLE's judicial panel, which is called the Committee for Individualized Review, or CIR. And they also send him a copy of the USMLE policies for handling irregular behavior, which say, among other things, that he'll be advised of the relevant findings of the USMLE's investigation, and he'll be given a chance to respond to all of them. Sometime around here, Dr. B hired an attorney, and, once you do that, it's usually best to let them do the talking. But he still responded to the letter from the USMLE Secretariat directly. Again, please permit me to let him speak for himself. Quote, "Dear Amy, after reading this email today, I suspected you have not yet received my lawyer's letter. Your email back in April was probably the most insulting thing I have ever read. It quickly became clearer to me that it is not safe for me anymore to handle this alone. For the record, unusual use of quotes here, but you do you, Dr. B, quote, never, end quote, provided any party with any information that I even suspected was false. Your formulation stating that I have shared incorrect information with anyone is deceiving, especially that it does not just question my morals, but also my judgment clarity. Why would I wait until FCVS collects my scores for me to create this issue? Please go ahead and schedule that virtual CIR meeting, and please account for the virtual presence of a lawyer. I'm happy to go through my email inbox on camera in the presence of a lawyer. Amy, please acknowledge the receipt of this email in person. Please respond to my lawyer and myself with dates. Best, Dr. B." All this stuff created issues for Dr. B at his residency program, too. There's one email from his program director to the NBME, which was confirmed as being authentic, saying, quote, "As Dr. B's program director, I'm in desperate need of his passing USMLE Step 3 report. It has severe consequences for him," end quote. This email is sent in March, but she says, quote, "I've been waiting for this for several months. I need to have it directly from the USMLE. I anxiously await your reply," end quote. But Dr. B admitted no part of anything that the USMLE was saying about him, and now he was lawyered up. And in June, he graduated from his residency program. And then, in August, he gets his hearing before the CIR. It doesn't go well. The evidence that he's engaged in irregular behavior, as you've heard, is strong. And Dr. B doesn't always help his own case. I mean, when he's asked how this score alteration could have occurred, well, he has no theories about that. Now, he doesn't have to. I mean, it's the NBME's obligation to prove their case against him, but it might have helped his defense if he had some alternative explanation for how everyone had ended up there, other than just saying that the NBME sent him an email that the NBME says they didn't send. Worse, at times he seemed to provide testimony that seemed inconsistent with the written record in his case. For instance, in his testimony, he emphatically said, quote, "If you will review every email I sent, you will see that I never requested a score recheck," end quote. But there was an email he sent to the FSMB in which he said that an NBME representative had, quote, "assisted me in submitting that request directly via their secretariat office," end quote. It takes a month, but on September 23rd, Dr. B gets a letter notifying him of the committee's decision. They find that he's engaged in irregular behavior, and they ban him from taking the USMLE for at least 3 years. But even then, they say they'll only lift the ban if they receive a request from a state board that wants him to take the exam and keeps wanting him to take the exam after the NBME has made a full disclosure of the events that led to the imposition of the ban. This is a devastating result for Dr. B. I mean, it would be for any physician, but remember, he's an international medical graduate who's in the United States on a visa. If he doesn't have a medical license, he can't be employed, and he's going to get deported. But he's got one last shot. The CIR's decision can be appealed to the USMLE Composite Committee, so Dr. B requests an appeal. But in the meantime, he's got to manage the fallout from the CIR decision. Once again, he catches a break from the state board, who gets notified of the NBME's decision. He tells them that he denies and refutes the CIR's conclusions in their entirety, and he promises that he's going to keep fighting to set the record straight. So instead of revoking his license, the board agrees to enter an order in which he voluntarily agrees not to practice medicine while the issues around his Step 3 score are worked out. That fall, he catches another break by signing an employment agreement with another employer willing to file a petition for an H-1B visa. So now he's got a license, a job, and a visa waiting for him. All he's got to do is win this appeal hearing. And that hearing with the USMLE Composite Committee is scheduled for February of 2021. But it doesn't go well either. Here, Dr. B gets a letter from the Composite Committee saying that they found that the CIR acted in compliance with USMLE policies and procedures. His irregular behavior and 3-year ban were upheld, and they say the decision will be communicated to the FSMB's Physician Data Center. So you might think this is the end of the story. I mean, after all, Dr. B is now exhausted his USMLE appeals. But this is America. And in America, there's one last place you can turn for justice: the courts. And there's actually one very important event that I didn't tell you about yet. After the first USMLE hearing, Dr. B hired a new attorney. So here, just for a moment, I want you to imagine you're that guy, picking up this case at this very moment. Go on, close your eyes. Think this through with me. Because I want you to feel in your nuggets just what a mess your client is in and what kind of odds you're up against. I mean, at this point, your client has just lost his hearing and he's been banned from taking the USMLE for 3 years. He's hanging on to his medical license by the skin of his teeth, but that's in serious jeopardy. And if he loses it, he's going to lose his job and get deported. So how are you going to get him out of this? And oh, by the way, the facts you have to work with are not really very good. I mean, you got a score report that within 15 seconds of inspection, anyone can see is a fake. Even worse, it's a fake that was generated from an actual score report that belonged to your client. And you got an email that your client says came from the NBME, but the text in the email is different when it gets provided at different times to different parties. And maybe there's a perfectly reasonable explanation for that, but you're still going to have a hell of a time convincing the USMLE Composite Committee that the NBME sent this email when the NBME is on the other side of the room saying, no, we didn't. The best piece of evidence that you seem to have might be this partial refund from the FSMB, but the paper trail around that is less helpful than you might have hoped for because the emails don't say a peep about having actually passed the test because of a score recheck, and instead they talk about struggling with personal issues that cause delays and provide documentation about visa troubles. So until or unless you get your hands on some new evidence, the best you might be able to do is work to convince everyone that your client was simply acting in good faith on a score report that he believed was authentic, but had actually been created by some malicious third party that was just trying to screw with him. And if you could do that, I mean, still, I think at some point you're going to have to contend with the question of when a reasonable person would have given up that good faith belief. I mean, sure, you can imagine a reasonable doctor getting a spoofed email from the NBME and then forwarding it back to them a few months later saying, yo, here's that email you sent me. But when they come back like, bro, we never sent that. And you're like, no, for real, you sent this to me. And they're like, no cap dog, we never sent that. I mean, how long does that back and forth go on? At what point should a reasonable person broaden their differential and recognize that they'd been scammed? But there's this famous quote from Carl Sandburg that's an aphorism for lawyers. If the facts are against you, argue the law. If the law is against you, argue the facts. If the law and the facts are against you, pound the table and yell like hell. And most of the facts were definitely against Dr. B. So the new attorney, I think, initially went with a mix of arguing the law and pounding the table and yelling like hell. He filed a big fat lawsuit against the NBME for a multiplicity of claims, including breach of good faith and fair dealing, breach of common law due process, breach of constitutional due process protections, negligence, violations of laws against unfair and deceptive acts and practices, defamation, and both intentional and negligent interference with contractual relations. But there were a couple facts, as he reviewed the case, that did go in Dr. B's favor. And ultimately, what formed the core of his case was this. See, after the new attorney took over the case and reviewed carefully the letters that Dr. B had received from the USMLE Secretariat, he noticed a problem. It didn't look like the USMLE had followed their own procedures when they conducted the CIR hearing. Remember how I told you that the USMLE policies say the individual has to be informed of the relevant findings of the investigation before the hearing and given an opportunity to provide an explanation for the facts that are going to be presented as evidence against them? Well, it didn't seem like that really occurred. The first letter from the Secretariat laid out multiple points of evidence against Dr. B that were used to explain why he needed to appear before the CIR. The second letter from the Secretariat, which conveyed the decision, did the same thing. Actually, most of the bullet points in that letter were exactly the same, like they'd just been cut and pasted from one letter to the other. But there were a couple of pieces of evidence that the committee had received that are mentioned in the second letter as being used in their decision, but they don't appear in the first. Specifically, there were written reports from NBME staff members describing their analysis of the fake score report and the email. And these reports do not support Dr. B's assertion that the score report and email came from the NBME. The analysis of the score report, a portion of which I'm showing you here, showed that the PDF had been created using a program called GPL Ghostscript, which, of course, is not the program that creates actual PDFs for actual USMLE reports. And worse, this PDF had been created at 2:52 p.m. on March 6th, the very day it was submitted to the medical board. Here's a portion of the email analysis, which highlights other little inconsistencies. For instance, the email closing is, quote, "yours faithfully," end quote. And it doesn't list a particular staff member's name with the signature. I mean, this is not the language or the protocol that NBME staff are trained to use in their emails, especially an important email like this. Even worse, the unit in the signature was listed as Examinee Support Services, but the NBME had changed the name of that unit to Customer Operations Management a couple of years before. I don't know what kind of explanation Dr. B might have had for these things, but the point was the NBME never gave him a chance to contemplate one before his hearing. And there was something else too that maybe wasn't a policy violation, but it maybe didn't quite seem fair either. See, leading up to the appeal with the composite committee, Dr. B had been asked to submit any evidence that he wanted the committee to consider by January 1st, so that'd be 5 weeks before his hearing. But that deadline came and went. And then, on the eve of his appeal hearing, his attorney sends an email to the committee, and this email drops a bombshell. It includes a written report from a person identified as a computer science professor and cybersecurity expert who analyzed the email that Dr. B says he received in July of 2019. And this expert says that the email was authentic and came from NBME. And as an aside, I would love to tell you what was in this report, but unfortunately it seems to only be located in the portion of the court records that remain under seal, so I never got to read it. And actually, it turns out that certain portions of this report were illegible anyhow, so the NBME had to spend a few months getting a legible copy. But all that's okay, because the USMLE Composite Committee, they never got to look at it or read it either. They sent back an email to Dr. B's attorney pointing out that since this evidence was received 5 weeks after their deadline, they had declined to consider it in his appeal hearing. These procedural concerns end up being the meatiest part of Dr. B's lawsuit against the NBME because they underlie the breach of contract claims. If the USMLE didn't follow their own procedures, then they didn't uphold their contract with Dr. B because both parties agreed to be governed by those terms when he paid his money to take the USMLE exam. So by August 30th, 2021, the court has a hearing on Dr. B's motion for preliminary injunction. And obviously, the NBME has their own attorneys, and they are led by an experienced, high-powered partner from a white shoe firm in Washington, D.C., and he tries to argue that these pieces of evidence that Dr. B didn't receive, well, they were hardly crucial to the committee's decision. I mean, there was more than enough other evidence for them to reach the conclusion they reached, right? And he points out that, every court has filing deadlines, and if you miss them, you're out of luck. And Dr. B clearly missed the deadline to provide this supposedly exculpatory expert report. The judge was unimpressed. He says, quote, "I can't imagine if this were a criminal case and a defendant came forward with exculpatory information the night before a hearing, a court wouldn't grant a continuance to allow it to come in and be considered. It does go back to whether the procedures were properly followed, And, I don't live in your world that you clearly live in, being attorneys for these folks in terms of, what's acceptable or not within the context of the USMLE. I have to look at the law. The law is governed by the policies and the procedures and the common law of good faith and fair dealing and whatnot. And it does seem to be that there are procedural problems here with the defendant's initial actions back in April, end quote. And he goes on to find in favor of Dr. B. Specifically, the court ordered the NBME to provide Dr. B with a redo hearing that comported with its own policies and procedures. And he went on to state that it was the court's intent that deportation be stayed and Dr. B be allowed to remain in the United States so that he could participate in his own defense in this redo hearing and finish out his lawsuit against the USMLE. So now I want you to imagine that you're Dr. B. What are you feeling right now? I mean, on the one hand, you must be elated. I mean, you've just beaten the NBME and its high-powered lawyers in court. That doesn't happen often. It's an incredible victory. On the other hand, you're probably still shaking in your shoes because in the end, all you've won is a do-over. You're stuck with the same set of facts you had before. And you best believe the NBME is going to come correct this time. You can be certain that they will have dotted every I and crossed every T when they come for you again. And they're coming for you again in just a few months. So how are you going to get out of this? You need an end run. Remember, Dr. B needs an unrestricted medical license. He needs a license not only so he can practice medicine, but so he won't be deported. And you might think, therefore, that he needs the USMLE. But if you think that, you're wrong. Every state in the United States requires passing some kind of an exam to get licensed, and the USMLE is certainly the exam that almost every MD uses to get their license. But every state also allows some other exams, even if those other exams are only permitted to be taken by certain examinees or in certain situations. So one common and obvious example would be that most states accept both USMLE and COMLEX for DO applicants. So if Dr. B had been a DO instead of an IMG and he'd gotten this strange email from the NBOME in July of 2019, well, he could have just turned around and taken USMLE Step 3 and gotten licensed that way. But some U.S. states also accept passage of the Medical Council of Canada's licensing exams, and it just so happened Dr. B's state was one of them. And here, once again, fortune smiled upon Dr. B. To get licensed using the Canadian exam, it used to require passing both Part 1 and Part 2 of the MCCQE. But then, in June of 2021, the Canadian Licensing Authority changed their standards to allow graduates of approved foreign medical schools to be entered onto the Canadian Medical Register as long as they'd passed the MCCQE Part 1 exam and had at least 12 months of approved postgraduate medical training. And Dr. B, of course, he hadn't just completed 12 months of residency training, he completed an entire U.S. residency. So he quickly took and passed the MCCQE. And so it came to pass that on October 19th, 2021, the state board allowed Dr. B to practice medicine and start working at a new job that he'd secured. If you think back to how this story started, this is an incredible, against all odds victory. But there are still two unsettled issues that I want to tell you about to wrap up the story. The first is what happened at the repeat CIR hearing, because there, of course, Dr. B's got one last shot to clear his name and set the record straight, right? And the second is what happens with the lawsuit, because, as you've heard, Dr. B has a judge who's sympathetic to the argument that the NBME violated their contract with him, and he suffered on account of it, so maybe there might be some money in this. Maybe the NBME could be punished for their breach of contract and Dr. B could be made whole. It would certainly help his case if Dr. B prevailed at his repeat CIR hearing, but you can imagine how that hearing went. Even with access to all the evidence that would be used against him, it went about the same as the first hearing. He was found guilty of irregular behavior. There was one interesting moment in the second hearing, though, when the panel again started asking questions about if Dr. B had any idea who might have created this fake score report. And in response to those inquiries, he offered up some idle speculation about how there was this one person, one of his residency colleagues, who used to come over to his place and therefore, perhaps, had the access needed to orchestrate these dastardly deeds, but he stopped short of naming names or even specifically positing this as a theory about the source of the fake email in the score report. Anyhow, once again, he appealed to the USMLE Composite Committee, and once again, he lost. So that's it. But on one very important point, Dr. B won, or at least he didn't lose. Like I said, the USMLE's investigation was thorough, but the USMLE Secretariat is not a police agency. I mean, they don't have any special investigative powers. There's no USMLE agent who's going to kick in your door with a search warrant or take you into custody and interrogate you. Their investigation gave them enough evidence to conclude that Dr. B had engaged in irregular behavior. But they had no direct evidence that he personally had created this email or fabricated the score report. And if that sounds like a minor point, it's not. Here's a screenshot from the board's website listing the requirements for physician licensure in Dr. B's state. Look at that first bullet point. I mean, before they get to talking about the residency training you got to have or the exams you got to pass, the very first requirement for licensure is that the physician has to be of good moral character. You know, almost all states have a requirement like this. So, to a medical board, there's a very big difference between the following two scenarios. On the one hand, a gullible but good-hearted physician gets played by a shadowy and morally bankrupt computer sophisticate who somehow gained access to the PDF of their USMLE score report and, for reasons only known inside their fiendish and depraved heart, decides they're going to break out GPL Ghost Script and try to end this man's whole career. Or, on the other hand, someone who themselves is so morally bankrupt that they forge the report and try to pass it off as being real. Now, in neither of these scenarios might this hypothetical person seem very smart or knowledgeable about how the world works, and both might have engaged in irregular behavior according to the USMLE. But only one has committed a crime of moral turpitude that would be disqualifying for medical licensure. Dr. B always maintained his innocence, and his attorneys vigorously asserted that at worst, he's definitely the first scenario. They've emphasized there was no direct evidence that Dr. B himself made or caused to be made these fake emails and score reports. All he did was respond to them. And as I said at the beginning, the board has heard all this. And when I look up Dr. B's name on the board website, he is listed as having an active medical license. So I think the board's position on this issue is clear. So that leaves just the lawsuit, which was dormant until the USMLE appeals were exhausted. But once those were done, the NBME cracked back on Dr. B. They finally responded officially to his lawsuit and asserted numerous affirmative defenses to all of his claims. His claims of defamation, for instance, they said should be barred because all the things that the NBME ever said about him were true. Actually, they argue that all of his claims should be barred by the doctrine of unclean hands because someone who engages in fraud and deceit shouldn't be entitled to relief from the court related to that matter. But they don't stop there. The NBME goes on to countersue Dr. B, alleging that he violated a computer crimes law that says it's illegal for you to access a computer for the purpose of obtaining property by false or fraudulent purposes. And they go on to say, actually, that Dr. B breached his contract with the NBME with his actions throughout this caper, so they should be entitled to recover their costs and legal fees at least, and maybe get some punitive damages too. And if you wonder what's the potential exposure here, well, to just give you a starting point, I pulled the NBME's Form 990s, and I observed that from 2020 to 2022, they paid $1,444,373 to the law firm that was representing them in this case. And I'm sure a substantial chunk of that was for work on this specific case. But here again, good attorneys come to Dr. B's rescue. They point out that this computer crimes law technically only applies to accessing someone else's computer, not your own. So they get that counterclaim dismissed. Now, the judge lets the breach of contract claim stand, but his attorneys foreshadow what, to me, seems like it might be a pretty good argument against the NBME getting their costs covered by the court. His attorneys point out that the fact that the USMLE has all these policies and procedures for dealing with examinee misbehavior shows that they anticipate that there's going to be some amount of irregular behavior that occurs that they're going to have to deal with. In other words, it's part of the cost of doing business. So, as his attorneys point out, that the costs may have been greater than the NBME anticipated in this case is nothing more than a risk that they assume when they set the fees that they charge examinees. What happens next is shocking if you think about how acrimonious things were throughout this dispute. But it's not shocking if you think about the position each party is in now. They both agreed to dismiss the lawsuit. For Dr. B, obviously, this makes sense. I mean, he won. Despite a horrible set of facts, he beat the USMLE in court. Or at the very least, he kept from losing for long enough that he was able to do an end run around them. I mean, if things had gone even just slightly differently, he might not have completed his residency, or he might have had his license revoked by the board, or he might have even gotten deported. But he didn't. So what more would he realistically expect to get from this lawsuit now? I mean, it's time to call game. And what about the NBME? I mean, their mission is to protect the public, and honestly, they honored that mission. So in some ways, they won too. I mean, sure, they got their wrist slapped by the judge for not giving every piece of evidence to Dr. B in a timely fashion, but they followed the rules, they won the redo, and honestly, they did everything in their power to keep him from becoming a licensed physician. But ultimately, that decision isn't theirs. It's the state board's decision, and the state board gave him a license. The NBME defended the reputation of their exam, and they defended the validity of the scores that go out under their names, so what more do they have to fight for? So for Dr. B and the NBME, this is the end of the story. But for the rest of you, I promise some lessons. And honestly, I think most of the important lessons about how our systems work and why they don't and when they don't, I think those lessons are self-evident from the telling of this tale, which is really the reason why I wanted to tell it. But as I thought about this, I did come up with 7 other lessons that some of you might find applicable to your own circumstances and career in medicine. Number 1, don't be stupid. This is for anyone out there who might stumble upon this video and think that it provides a blueprint for them to use to beat the USMLE. It doesn't. Folks, you can't fake your USMLE scores. And in fact, this sort of obvious fact was used as a defense at one point by Dr. B's attorney, as in, this is such a freaking stupid idea, no one would ever do it, because, and I quote his attorney here, quote, such a scheme would be nonsensical and utterly improbable, as every resident and any thinking person would know. There are no circumstances in which it could any way be successful, end quote. I told you how much the NBME spent on legal fees, but only Dr. B knows how much this whole episode cost him. I mean, his legal bills alone have got to be into the 6 figures, and I can only imagine the volume of cortisol and catecholamines his body had to endure as he existed in a chronic stress state, seeing the walls repeatedly close in on him over the course of several years. So if you're thinking about faking your USMLE scores, all I'm going to say is that you can get a gently used copy of First Aid for the USMLE for about $20 at the online bookseller of your choice. Lesson number 2, don't get kicked off the island. One of the most surprising events in this story was the moment that Dr. B got his medical license from the state board despite not having a verifiable Step 3 score. But regardless of how or why or whether that should have occurred, I think this ends up being among the biggest inflection points in the whole tale because it put Dr. B on the inside of physician self-regulation. And what I've seen time and time again as someone who from time to time follows these kinds of gruesome stories out of curiosity is that if you manage to get inside and keep yourself inside the physician's self-regulation apparatus, you end up a lot better than if you don't. If you come in too hot or you act hard-headed and you get kicked off the island, you're going to have a long road back. But if you assert your rights but are willing to humble yourself and bend with the wind, most medical boards, and I guess I should say the same thing for medical schools and residency programs, they'll work with you. They'll help you with your substance abuse issue or your mental health struggle or even your unprofessional behavior or sometimes your financial impropriety. Now, sometimes people do things that are so egregious that you give people no choice. But often the crime is overcomable, but people self-identify to the board as being the kind of person you can't work with, and they suffer more on account of it. Although, in those cases, I guess I couldn't say they suffer more unnecessarily. Anyhow, if you ever find yourself in trouble, do whatever you can to stay on the island. Lesson number 3, lawyer up, early and often. Make no mistake, this story would not have a happy ending for Dr. B if not for the fact that he hired attorneys pretty early in this process. I mean, that alone made people in the residency program and the board and wherever else treat him more deferentially. And his lawyers were able, ultimately, to slow down the speeding locomotive just enough to keep it from crushing him after that first CIR hearing. And they were able to fight aggressively enough and successfully enough from that point forward for Dr. B to remain licensable as a person of good moral character. Now, maybe there are people out there who hire a lawyer early and they end up saying, man, I wish I hadn't done that. But if these people are out there, I don't end up hearing their stories. Number 4, privilege matters. Come to think of it, I guess this may be more of an observation than a lesson, but I promised 7 lessons, so here goes. As I followed this case, there were multiple times when I had to question if this story would have played the same way for someone else, someone slightly different than Dr. B. I mean, suppose it was a female resident physician sending those rude, pushy emails. Would they have ultimately gotten their way? I mean, what if the emails were from a doctor whose email signature didn't prominently include the crest of an Ivy League school? Would that person have gotten the benefit of the doubt? Or what if it was a doctor who wasn't traditionally good looking or didn't have a sob story about personal struggles? Would as many people have been willing to withhold their judgment or even take their side in a he said, she said with the NBME? Or maybe most obvious of all, what if it was someone who didn't have the personal or family financial resources to pay 6 figures of attorney fees? Would they have been treated the same way? Where would that person be now? Back in the spring, Dr. Adam Sifu, one of the authors of Symptom to Diagnosis, he highlighted a quote that's kind of stuck in my head since then. The quote was, quote, "Regard for power implies disregard for those without power," end quote. So I guess all I can say is that if you're listening to this and you ever find yourself caught up in one of these situations where you have to make a professional judgment, try to maintain some awareness of what kind of power you're giving deference to so that you can give every person who's in the same circumstances the exact same treatment. Number 5, policies are your best protection. A while back, I made a video giving my general advice to someone who's being kicked out of medical school or their residency program. I'll link to that below if you missed it, but I made this point then, and I'm going to make it again now because, by God, if this case doesn't provide a perfect real-life example. If you are in hot water with your school or your residency program, you better make sure you follow every policy to the letter. And if you can find ways that the school or the program didn't, those are going to become some of the sharpest arrow in your quiver if things do escalate. And of course, the flip side is also true. If you're listening to this and you're a program director or a school official, you know you can't just get rid of an incompetent or unprofessional trainee. You have to get rid of them in strict adherence to all the policies that govern getting rid of them. So don't skip a rung on the ladder or you might fall. Number 6, know when you're beat. Now, this is a lesson you could take from a few different moments in this story, but the one that I'll hone in on is that time before the redo CIR hearing when Dr. B passed the MCCQE. When you know you're holding a losing hand in whatever scenario that might apply to you, you don't necessarily have to fold, but you sure as heck don't want to go all in and stay all in. You should try as hard as you can to find any other way to win so that you don't have to show your cards. And as far as I can tell, the single smartest thing Dr. B did in this entire 4-year period was to quickly and quietly pass an alternative licensing exam. And finally, number 7, feel gratitude for good luck. And I'm going to say this because number 1, I like to end on a positive note. And number 2, the older I've gotten, the more valuable I feel this piece of advice is. I'll tell you what I mean. I think I highlighted many of them, but there were a lot of very influential points in this story that happened the way they did, really because of just luck. And I mean, obviously, a lot of that luck was the impact of COVID on this entire story. I mean, lots of things wouldn't play the same way in 2024 that they did in 2020 or 2021. But the point I want to make here, I guess, is really more of a philosophical point, which is that all of us are really good. I think we keenly perceive times when we suffer from bad luck. But we tend to look right past times when something good happened, or maybe something horrific was avoided, for no reason other than that's just how the dice landed. And I know it's cool on LinkedIn to make hustle porn about how hard work makes good luck, but I'll tell you, sometimes it just happens. And I think that you'll find that you're a happier, more balanced person if you recognize and try to feel gratitude at those times. And once again, that's all I've got. Thank you for listening.